So today what we're going to do is cover a bit of background about what CCPA is, why it came about. But before that, what we're going to do is also talk about how the legislative landscape of the states works, because it is quite different to New Zealand. And in order to get the context for California, we're going to need to do some back explaining. We're also going to talk about who's in scope of CCPA. Now that might sound simple, but it will get quite confusing quite quickly. We're then going to talk about some key terms, what rights people have under CCPA, and also how it compares to New Zealand and the GDPR as well. So first we're going to kick off with a bit about how legislation works in the states. So unlike New Zealand, the states has a federal and a state laws. In terms of how it works, the federal can set laws that cover all states. The individual states can set their own laws as long as the federal law doesn't prohibit them from doing that. So they, for example, for the Health Information Portability Code, so HIPAA, actually the federal states can set their own laws on top of that that are actually more restrictive than the federal law. So some states have done that. Whereas laws like the CAN spam, and that is not a law that allows you to spam people. That is one that prevents you from propagating porn and sending marketing to people. It's unfortunately named. That federal law says that the states can't set their own laws for it. So it is needed to be taken in context for it. Now, in terms of California have gone forth and set their own privacy laws. So otherwise known as the CCPA. It's worth knowing, though, that actually California in their constitution had a guarantee of privacy since 1972. Now that's interesting because not all the states do have that right. So California has been quite forward for quite a long time in the privacy space. In terms of how it came about, originally there was a ballot for changes to put in the Privacy Act. And it actually got more ballots, more signatures on that ballot than they needed in a quite short space of time. They had nearly twice as many as they needed. But in parallel to that ballot being produced, the actual state had gone forth and done CCPA anyway. So they prepared it, researched it over 2 years. So you'll see elements of GDPR, you will see elements of other legislation in there that will be familiar. So they prepared it over 2 years. That said, they did rush it through. So although they prepared it over 2 years, there are bits that are vague. They are changing it and issuing additional instructions nearly daily on things. And to make it even better, there's already a ballot to write a new version of it. So it is a bit of a moving feast. In theory, it came into law the 1st of January this year. However, the regulators already said they're not planning on taking action against people for non-compliance till at least June. But we will see how that actually pans out. Worth mentioning as well, the Attorney General of California can actually issue regulations on top of it. Okay, so we've got what's in the legislation. The Attorney General can issue his own regulations on top. So in other words, the Attorney General can sort of add to it as he goes. So for example, in the last couple of weeks, the Attorney General has added a requirement that all individuals handling consumer inquiries about privacy or business compliance with CCPA are fully briefed and informed about the requirements of CCPA. So they've put very operational stuff in that you won't find in the primary legislation. So in order to work out what your requirements are, you're going to need to look at the primary legislation and then every one of these directives that the Attorney General has issued to get a full and complete picture. So it's not quite as easy to get to the bottom of stuff as you would hope for it. So the key question we're all wanting to know, does it apply in New Zealand? So I guess first of all, a bit of a show of hands, who thinks it applies to their organisation in New Zealand at the moment? No. Okay, interesting. So, first of all, bit of a warning. Unfortunately, today we can't do pretty pictures of dogs, and we are going to have to talk about legislation. So it will get a bit word heavy. to begin with while we just work through some of the pieces of the ledge. So, who does it actually apply to? So, first of all, CCPA, unlike the New Zealand Privacy Act, only applies to businesses. Okay, so that's the first thing. But the definition of a business is not set. So the first question is, am I a business? Interesting question on that one. But even then, it's not that simple. It's not every business. There are some carve-outs for it. So, in order to be in, you need to have at least yes to one of these questions. And when you look at them, you think, great, questions are easy. How much interpretation can there be to these questions? So, first up, we have to have grossed 25 million USD. Okay, so for a New Zealand company, does that mean grossed it in the States or grossed it worldwide? What exchange rate are we working on, yesterday or today? You know, so there's a bit of grey area on whether you're grossing 25 million USD. Or do you annually buy, receive, sell or share for commercial purposes 50,000 people's personal information about consumers, households or devices? Now, interestingly, you will already see that there is a difference to the New Zealand Privacy Act there. Personal information, we don't usually consider everything about households or devices personal information in New Zealand. So that definition is wider and we'll talk a bit more about that later. But also 50,000, how do we count that? How are we actually sure? So for example, personal information under their definition can include IP addresses. So their logs that are hitting your website from California might have 50,000 IP addresses from Californians in. Yes, you collected them. Is that enough to bring you in scope? Maybe, if you know they're in California. Also, are you a company that sells other people's information? So do you derive 50% of your income? Again, is that your income in New Zealand? Your income worldwide? Hard to know. But do you derive more than 50% from selling stuff? So normal people you would expect to find in there. Facebook, Google. You know, they make their money by selling you. You are the product of it. But even in New Zealand, we have SaaS providers who sell you to make money. You know, they're not that far out there. So we do have in New Zealand SaaS providers who fit in that bottom category. We have a number of SaaS providers who definitely fit in the second one too. You know, they deal as one of their primary markets with California. And it's quite common for New Zealand businesses, their first foray into the States, they want to go to California for some reason. It's where all dreams are made and broken, apparently. So, we thought about it and we think we've worked out whether we're one of those tick boxes to begin with. Then we need to have a think about whether we are actually a business in scope of here. So, to be a business, we have to be a for-profit organisation. So what you will see in the States at the moment is a whole bunch of organisations suddenly decided they were charities. They suddenly shifted. They're all charities. They don't now want to be in scope of this. There's some funny charity stuff going on. You collect consumers' personal information about people, or someone collects on your behalf. So that's about using an agent. So it's not okay to go, well, I didn't collect it. I paid someone else to collect it for me. Okay, you still collected it. It's still collected for your company, for your business. You alone or jointly with others worked out why you were going to collect the information. So if you're familiar with GDPR, what it's indicating is you're taking the role of the controller for GDPR. So you are the one who's deciding how the shots are called. You are deciding what your business does, etc. Now, the most hard one about this, you need to be doing business in California. So, doing business in California, helpfully, is not defined anywhere in the legislation because that would be just too easy. In good news, we know what California is. We've got a geographical split for that. But what does doing business mean there? So, first of all, we need to have a look at what doing business means. There is a key definition in this that helps, and that is the definition of consumer in the Act. So that is a natural person who is a Californian resident and dealing with them. However, the Californian resident does not actually need to be resident in California at the time to always be in scope. So sometimes there might be some grey areas on that one, and we'll talk a bit more about those in a minute. So, who now thinks they might be in scope? Thinking about that. Or who's now a bit more kind of wondering if they've suddenly fallen over the line potentially? No. Okay. So, we talked earlier about what personal information is, and we said it was wider. So, under the New Zealand Privacy Act, it needs to be personal information relating to a living, identifiable human being, with the exception and the slight quirk that is the death data held by the Registrar General, then that is also in scope. But generally we know what that is, and that is the same definition used in GDPR as well. Living person, living, breathing person. Before someone asks, one of the government departments did take legal advice. The dogs under New Zealand privacy law do not have privacy rights. One of the government departments has already had to do that for a case they had. So, what does it mean for California though in the CCPA? So their definition on the surface looks quite a lot wider. Their definition says identifies, relates to, describes, or is reasonably capable of being associated or linked to a consumer or household. Okay, so that's quite a bit wider potentially. But actually, when you boil that down, it most probably is not a huge degree wider. So that does mean that items such as your cell phone, items about your house, how much power your house has used, how often you empty the bins, those sort of things will be in scope. However, even in New Zealand, you can argue that sometimes those are in scope anyway. Because if you live on your own, how often you empty your bin and how much power you use is actually about you. So, it is maybe the grayer areas of New Zealand law, but it isn't, it is the same considerations in general. In addition, personal information also includes audio, electronic, visual, thermal, and inferences drawn from the information. So it does go a little bit wider. Now, there is a common misconception that actually the CCPA definition is wider than GDPR. If you actually boil it down though, the CCPA definition is actually quite a lot tighter than GDPR. And that is because it excludes a whole bunch of stuff. So for example, health information is excluded from CCPA. And that is excluded because they have a separate law for that. They have a federal law, the health information, the HIPAA. So they already have a law. They don't need two. Get confusing if we have two for the same thing. So we exclude that bit out. We also exclude things like credit reporting. Again, we have a federal law for credit reporting. We don't need two. The other quite key exclusion, if you've got employees who are based in California, initially for the first year, it does not include employees and employee relationships. And the main reason for that was that they were unsure what to do in that space. So they gave themselves a whole nother year to work it out. As yet, it's not clear what they're going to do. Years ticking away, so hopefully they will give some guidance on that shortly. There is also a slight carve out around this as well, and that is around publicly available information. Now again, we have the carve out in New Zealand for publicly available. However, just watch, the definition under the CCPA of publicly available is quite different. Publicly available under Californian law means issued or held by a federal, state or local government. Okay, so it doesn't mean something you found on Facebook because someone left their profile open. It means things of public record. So it is your birth record that they hold on a public register. It is not stuff you found on the internet. Okay, so it is a bit tighter on that one about what you can use. So if you have one of those businesses that decides that surfing and scraping off the internet is a good thing and it's currently flying under the radar in New Zealand because it's publicly available, in California it may not be flying nearly as well. So, are your customers consumers? Okay. Are they not the same? Well, no, not every customer is a consumer. So, first of all, the consumers need to be a living person, natural person. They then need to be a Californian resident, okay? They do not need to be in California though. They just need to be a resident. So they might have left California, but their normal place of abode needs to be California, okay? Easy way for the US to check if they're resident, where do they pay their taxes? Okay, if they pay their taxes in California, they're resident in California. You can only pay your taxes in one state, so that usually irons that one out. It also includes people who are temporarily or transiently in California. So we've got the Californian residents who've gone wherever they want in the world, and then we've got the people who visit from New Zealand. So if we leave here today and all go and sit in California, we'll be in scope. Okay, so it includes their visitors. Now, before we all panic and think, oh my God, when they all come from California to visit us in New Zealand, they're still going to be in scope. There are carve-outs for it. So before we think it will pull every business in New Zealand in, what they do say is that if the full process, so if we collect the information when the person is outside of California, we don't sell it or do anything with it in California, and we don't collect it while the consumer was in California or sell it while they're in California, then we're all good. But just think about the example. If we have a Californian resident who visits us on the waterfront here and they're going to eat their dinner, okay? If they make their booking from California before they come, because our restaurant's so great and it books up really far in advance, we're suddenly outside of that exclusion. Okay, so we might in New Zealand have companies that are falling in if they are the top tourist destination from California. Okay, but again, it's 50,000 Californians. So, you know, we've got to be a pretty good tourist destination. Cool. Still slightly confused. The biggest thing for CCPA that people are struggling with is to work out if they're in scope. That is the biggest challenge. So once you've worked that out, the next stuff comes reasonably easy. But a lot of organisations are struggling with the, am I in, am I not? Oh, maybe I should just go with I'm in because it's lower risk to me. And we'll talk about what the impacts of getting it wrong are in a minute. In New Zealand, we still have companies who have decided to sit on the fence and wait and see what happens, see if the Attorney General issues maybe some more instructions on what some of these things mean, hoping that the Attorney General is not going to notice them on the other side of the world. Depending on your business, that might be okay. If you're a large bank, that's most probably not the most appropriate decision to make. If you are a small restaurant down the waterfront, maybe, you know, really depends how much your presence might be felt. So there is another category though that pulls people in New Zealand if you're not in scope of originally. And these are service providers and data brokers. Now we have lots of these in New Zealand, and lots of the people in New Zealand first found out about CCPA when they started receiving new contracts from Californian customers. Okay, so a service provider is, in effect, an agent of a company who is in scope. Okay, so there's someone who does something on their behalf. Exactly the same way as New Zealand, we have the concept of an agent delivering service. That is that. If we were talking about GDPR, that is the processor. They do something for you. So you ask them to, I don't know, issue tickets on your behalf, or you ask them to print something for you. Or they are people like AWS, etc., where you ask them to host your data in their cloud. It could be any of these. We have lots of SaaS providers, software as a service providers in Wellington particularly. Okay, so we've got lots of these people who are suddenly discovering, oh dear, I am one of these people. The other strange one that was added really late on, so it only actually got added in October last year. So remember we said that things were put in the very last minutes of stuff. This went in October, and bear in mind, it went law 1st of January. It went in late October. Is the concept of a data broker. So a data broker is someone who knowingly collects and sells to third parties personal information. Okay, so they're kind of like a warehouse where you can come and buy people and their stuff. So some of the common ones, Facebook, Google are the big ones, but there will be other people who will find their business model means they are a data broker. If you are a data broker, or you think for some reason you have become a data broker, the Attorney General requires you to register with them as a data broker before January 31st, the year after you have been a data broker. So you do a whole year's trading as a data broker, then you register and say, hey, for the last year I've been a data broker. We're not quite sure what's going to happen after that because the Attorney General hasn't issued any more instructions about what that means. I'm expecting it means as a register and something will happen, but we will have to wait and see what after January next year brings on that one. They have just produced their first list. Cool. So we can go and have a look who all the data brokers are in the world. So now we've worked out whether we're in scope or out of scope and which kind of in scope we are. Some differences to the consumer rights. So the consumer rights under this are different to the New Zealand Privacy Act. Some are the same, some new. First up, and the one we've heard most about, is the right to not have my information sold. Okay, so that is the right for me as a consumer to go and say, I don't want you to sell my information to Google. I don't want you to sell my Facebook stuff to every third party off the back of it. Interestingly, what you mustn't do is you mustn't take action against someone who enforces that right. Okay, so you can't discriminate because they want to use that right. The other piece to it is you need to make it abundantly obvious if you are selling their data. So what you would have noticed in a whole bunch of privacy notices, policies, etc., is this funny do not sell button suddenly randomly appeared. That is them meeting their obligation. So it needs to be obvious and they need to be able to opt out. If they have opted out, you need to actually action it. It is not okay to then go forth and sell it anyway. A lot of people are having problems with that. The do not sell button doesn't work. Or actually they just carry on. So sort of they've got the shop front looking right, but yeah, it's a bit broken behind it. And that button needs to be available at any time when you collect personal information. So you will quite often see it at the bottom of the web pages, you know, one of the options on it, etc. They also have the right to deletion. Now, some of us will recognize that from GDPR. So you have 45 days to action someone's right to deletion or to ask for an extension of another 45 days. So it is a slightly different time frame to New Zealand and to GDPR to deal with it. However, there are 9 different exceptions to when someone can delete something. So you can ask a company, please delete everything about me. And they've got 9 different reasons why they can say no. There's a fairly large amount of wiggle room in no. So a lot of people are managing to go down those rabbit holes for it. Interestingly, if they want to enact that right of deletion, it has to be free of charge. Okay, so a lot of the companies are now starting to make APIs, example, or make it automated. You want to delete your stuff, press this button, it will go away. Because you're doing it for free, you don't want to have man people sitting behind it. But bear in mind, if you're a service provider, so one of those agents we were talking about earlier, you need to be able to flow that through to your systems. So when your customer in California says, hey, this consumer of mine pressed the button and said delete, it needs to flow all the way down through all of the systems right to the very end and be deleted. So you need, if you are one of those service providers, to have some capability of doing that. Most of those service providers would have built it anyway for GDPR. It's no different, exactly the same. Get rid of it. Interesting, so they have the right to be informed. So that's the right to access their information, okay? However, that is slightly different. It's only access the information you have collected in the 12 months prior. So you can have 10 years worth of stuff about this customer, but you only have to give them the last 12 months. The other thing is the customer is only able to ask twice in 12 months. Okay, so you cannot be like some of the government departments here who get every week the same person keeps asking for exactly the same stuff. Okay, you can only get 2 times, so you better spread your 2 times out through the year to ask Facebook for your information, you know, appropriately through the year. If they want to use those rights, you have to give them 2 available mechanisms to do that. And it's actually set out in the legislation that at least one of those needs to be toll-free number and one of them needs to be on your website. Okay, so you've got forced down that avenue of how to deliver that to customers. The other one, as I say earlier, the right to be informed. So that is your privacy notice, privacy statement you've got on your website. There is some interesting additions that you have to put in that notice. You have to put in that notice the categories of information you collect and what information you sold in the last 12 months. So this allows people to make an informed choice about where they want to select that do not sell my info button, because you've had to show your last 12 months. And you have to update that privacy notice every 12 months minimum to make it current. So unlike New Zealand, you've got to keep revisiting that. In New Zealand, you should be revisiting that anyway, but you're going to have to keep revisiting it. Also, it is meant to be an easy to read language, and they've explicitly called out it needs to be understandable by the average consumer and not include technical or legal jargon. Okay, so it needs to be for a normal person to understand. So plain English writing needs to come into force. But it also needs to be available in all languages that you provide contracts for service in. So if you are Microsoft and you provide a contract for service in 47 languages, then your privacy notice needs to also be available in the matching 47 languages. It's not as easy as it sounds to get all your legal stuff translated into and make sure it's actually a good translation across those. It also needs to be available to people with disabilities. So in New Zealand, that goes without saying, but in California, they've explicitly called that out. Needs to be available through a screen reader, etc. So the last right, and it's one we don't have in New Zealand, the right to non-discrimination. So that means that anyone who enacts the other rights we just spoke about cannot be discriminated against. So if you are that person who wants to make 2 requests to receive your information and to delete it twice a year, etc., you can't discriminate against them. However, you are allowed to set up schemes to provide financial incentives to sell your data. Okay? Fine line between what's discriminating and what's an incentive on it. But yeah, interesting. So, what happens when we get this all wrong? There are 2 kinds of penalties you can get. The Attorney General can take his own injunction or civil penalties against you. So that's just the Attorney General. And that can be about any part of the legislation you didn't get right. Okay? So he can take up to $2,500 per violation if it was accidental, and $7,500 if you intended to do it and you willingly did it. But there is also nothing in the legislation that says they can't compound these. So while the Attorney General is admiring your one issue, If they find 10 more behind it, they can fine you for every one of them. So that bill could add up pretty quickly if you're non-compliant. The other one is they gave the right of private right of action to individuals. So that is individuals in California can sue under it. Okay, they can take a court case. They have the ability to get up to $750 per incident or the actual damages, but they can only sue for a breach. Okay, so it's not anything you've done wrong across the whole legislation, just for a breach. And even then, under a breach, they're not allowed to sue if the data was encrypted or redacted. Okay, so if a company actually did stuff and it still got out, then they're not allowed to sue under that. But if the company left it in clear text on the internet and it got out, then absolutely. We're thinking about though, that's per consumer. So if you have 1 million consumers, that could be a lot of money really quickly, coupled with the Attorney General's bill that's likely to accompany it. Okay, and the US is pretty litigation happy. They have no concerns as private individuals on wanting to take a court case. It's normal for them. In New Zealand, we're not used to that. That's not our normal mode of operandum. So in terms of New Zealand companies, that can make the risk profile of non-compliance quite different when dealing with Californians, because they are more than game to go down that route. So let's have a look at how the two compare. So first up, the rights. We talked earlier about this. So we've got the New Zealand, we've got access, be informed, and the correction. Again, under California, you see we have no correction. Okay, so under CCPA, there is no correction at the moment. We talked earlier about that new members bill to put in additional changes. Correction is one of them. So actually, California is quite a bit behind some of the other countries and some of their stuff. Cutting edge for the states, but quite behind other places in the world. We don't have some of the GDPR ones that came in. So we do not have that right to portability, that right to object to processing, etc. Kind of we have the object to processing, but it's only about selling your information. So it's quite a small objection versus the GDPR one. The fines, we said earlier, the fines are different. So New Zealand's new Privacy Act has fines. They're up to 10,000 NZD at the moment in the current draft. Not expecting that to change in the final version, but we will see how that goes. And we talked earlier about the consumer and the civil for California. For GDPR, when you compare it, you've got the 2% and the 4% of your annual turnover fines for GDPR. So likelihood is if you had a breach, actually, California, you may end up with the biggest bill because you've got each of those individual consumers with no cap on them going through, plus those Attorney General fines adding up for each bit. GDPR is capped at 4% or 20 mil, whichever is your biggest. So you know what you're up for under GDPR. You have no idea what you're up for under California. It's unlimited in some ways. So, once we've now worked out what we need to do, how do we actually get ready and what are we seeing in New Zealand? So, first thing to say is we have seen lots of people in New Zealand still trying to work out if they're in scope or not. Companies, as we said earlier, some of them have taken a risk-averse method and gone, well, actually, it's not hugely different to GDPR. It's not a huge amount more work. I should just go ahead and do this, and then there's no avoidance of doubt on it. The next thing is, what is your personal information and where are you sending it? So in order to work out if you are selling data particularly, you have to know what data you had in the first place. And you have to know what of your vendors or relationships you are sending that data to. So some places where you will be surprised to find you are selling your personal information. Google Analytics, the free version. You are selling your information to Google. They don't give you no money for it, but you are gifting it to them. It's a form of sale. Okay, so if you haven't read all your T's and C's on all your great services that you bought for free on the internet, likelihood is you're selling a whole bunch. So you need to work out, what is that? And is that okay? You also need to work out, what am I collecting about Californians? Do I actually know? In some cases, it's quite clear cut what services you sell to California. In other cases, less so. Vendor contracts. So one of the key changes we talked about was that vendors were coming back with new contracts to New Zealand companies. The reason for that is the companies in dealing with the Californians are ensuring that you are not selling the data. So they are coming back with additional clauses in saying, you must only use the data for the reason I told you to. You must have confidentiality on it, etc. So there are about 8 or 9 new clauses that are required for the Californian work to be done. So vendors here are receiving those new addendums, etc. coming through. One of our customers, a SaaS provider, was getting 10 a day coming in from California. So it is about, some of those customers have decided, well, actually, rather than getting all of these individual addendums, which are a nightmare and they're all particularly specially different, we will just update our general terms of service and put all these clauses in so that we don't have to deal with every special one. Other people have gone, well, we don't get that many California customers, we can deal with their special ones. So again, choice, how you want to deal with that. Thinking about what it means for your consumer request process. So most of the companies have got a Privacy Act process. We know how that one works. We've got it sussed. Some of them have got a GDPR variation on a theme. Okay, so now you need to know, is that person in California, are they covered by CCPA? And what do I need to do for them? And making sure that enacts. Some people have decided that they will take the highest bar, which is usually GDPR, and just deliver that to every customer rather than trying to work out where in the world they are. Because otherwise, by the time you've worked out where in the world they are and everything else, you've usually collected a whole bunch more personal information than you needed in the first place. And there is no fine for giving better service. So, nothing in here says you can't give a New Zealander the right to deletion. Nothing in our Privacy Act says you can't do it. So maybe I should offer it to everyone. Under CCPA, we said, you can only do your right of access every 6 months. Minimum. But that's fine. Nothing says you can't do it more often. So maybe I should, because it's just easier. So they're sort of working out where the fine line is. It is not practical if you are a company that deals with every country in the world to have a Privacy Act process with every country called out in it. The poor person at the end dealing with those requests will do their nut really quickly and screw it up. Okay, so just think about how it scales. Updating your privacy notice. We talked about this earlier. This is that do not sell. But this is also that information about what did you sell in the last 12 months. Sounds easy, but as we said earlier, first you've got to work out what it is. You've got to do that data flow work and work out what did you sell, so that you can actually write something sensible. It's not okay to write in your privacy notice, we sold some stuff, but we're not sure what it is. Okay, that's asking for trouble. So putting that in, also putting in how the person enacts their rights under California. So you might need to embellish the section of your privacy notice to give those additional rights in, for example, and provide some details. You also need to include the details of who going forward you're going to sell info to. So you might need to add, rather than my partners, you might need to actually link and provide a page about who your partners are for it. And not forgetting that, that Californian toll-free number. It needs to be a Californian one, not a New Zealand toll-free number, a Californian toll-free number. So actually arranging it and getting it on your website, and then actually making sure, if you're a New Zealand company, that it rings in New Zealand. Got a whole bunch of people it apparently doesn't ring here. Yeah, Go figure. The other thing to think about though is those Californians are going to ring you on that toll-free number in a time suitable for California. That is not necessarily a time suitable for New Zealand. So what are you going to do about that? Are you going to ring them back? Are you going to have an answer phone? You know, there's some very practical things about what to do with it after they call. It goes without saying that you need to have robust security controls. So there need to be reasonable security practices to protect the information. Under New Zealand law, you should have reasonable security practices anyway. But if you maybe are a bit iffy on it, it might be a good time to have a look. Remembering that fine for personal against personal comes as a result of a breach. So if you don't want that ever-increasing list of fines, that might be where you want to focus your attention on. Also, we talked earlier about that requirement that the Attorney General has introduced where everyone needs to know about CCPA who's dealing with it. So how are you going to do that in your organisation? Is it training? Is it awareness? Is it some sort of quiz, etc.? So you're going to have to make sure all your staff who deal with Californian customers have got that across them. So, as we said earlier, California and the CCPA is complicated. The biggest complication is working out if you're in scope. After that, it is reasonably straightforward. It is an uplift to New Zealand, but it is not a huge uplift. If you already have GDPR, it again is not a huge uplift. It is some minor points around the edges for it. But equally, it can't be taken lightly. You know, the fines are reasonably substantive, so you do want to take it seriously if you are in scope. But before we all go away and think, great, California doesn't affect me. First of all, there is the ballot we talked about earlier. California CCPA 2.0 it's called. They're going to change it most probably this year. They've got enough signatures on it already. So that's going to introduce the right to correction, a concept of sensitive personal information like we have under GDPR, and even better, create a government agency to enforce it. So likelihood is we're going to see better enforcement if that goes ahead. There has also been conversations about whether we should put in the right of portability, etc., to match up some more of those GDPR rights we had. But the better news is, as of the 10th of February, we also had 11 other states who all looked at California and thought, oh, wow, that's wonderful, and have all decided to start and put theirs into. So at the moment, we only have California and Nevada with their own state privacy. If we get all those other ones in the next 12 months, you are going to have to make some quite substantial changes. The other bad news is they're not all consistent. So they have varying definitions of sale. They have varying scope statements about who's in scope, etc. They also introduce things like, one of them introduces risk-based decisions. Okay, not something similar for California. Over half of the bills introduce that right of private action by an individual. So about half of them will introduce that individual fines from people. So, you know, planning for California is one, but you most probably need to keep an eye on the rest of the US, because if you're dealing with California, likelihood is you deal with the other states too. So keeping an eye on what's going on. In the US, they tend not to give a huge amount of notice. So unlike the New Zealand Privacy Act, you've had 6 months and it's going to be set in stone pretty quick and it's not going to change. California, we're making alterations to theirs in December. So you may not get a huge amount of notice on what you need to do and be ready for. So part of getting ready is to get to best practice now. If you're already at best practice, it will be slight additions to it. But if you're not making best practice, likelihood you've got a long way to go in sometimes, depending on what it is.